On count one, you are guilty of a contravention of section 4.1 of the Act, read with the other legislation on trafficking in persons in relation to Joslin Smith. On count two, you are also convicted of kidnapping in relation to trafficking. Can I just ask the public,
Guys, I don't know if you guys have seen this video of the reaction when the judge in court actually dished out the not the sentences now, but kind of like the judgment for the mother and those acquaintances in the disappearance of the little Joslin Smith. Really sensitive topic, really sensitive event that actually took place in South Africa. Really touching, because it must actually take a lot. It must actually take a lot for a mother who actually gave birth to the whole pain. I know the pain, the 9-month pain, pushing out the baby. Really, I respect women so much, and for a mother to get to the point where they have to be engaged in kind of like events that end up in the disappearance of the daughter. In fact, some media outlets actually, in a really sensitive way, describe this event as a mother selling the child for about $1,000 to a Sangoma. Really touching descriptions. And one of the things that actually I found really interesting as this judge Rasmus, I think that the whole case, the way he administered the whole case step by step, day by day, I was following each day. I'm so impressed, with his professionalism. And this is what I actually speak about. When you find a professional in South Africa, bro, you have to, take your hat off and salute. I salute this judge because I learned a lot from the process. It actually took me back as an academic to the whole thing with Socratic questioning. This whole questioning, how questions, if you ask the right question, you could actually make a person break down. I think this is the strength of lawyers. All right, they can ask you one question, and that question seems to tear into your soul. And this is actually one of the events that happened with one of the accused or so. I think there was a question that hit her. She didn't know when she broke down. She couldn't even get out of the course, So in this case, this moment here, when the judge now, after the whole lecture, he had actually about a 2-hour lecture, describing how the different stages and the development and the whole thing that went up with the case, and how eventually they've come up to a conclusion that these three are guilty. I was really taken aback how the whole court, rose up, with excitement, clapping, because I'm many times I'm really wondering why the judge even had to, solicit the crowd not to kind of like intervene or disturb the process, because it came as a shock even to the accused, Joslin Smith's mother, and the other guy. You see them in this video, that they were so shocked when the whole people started clapping. They thought they were clapping for some other event, but the people, it tells me a South Africa that is hungry for justice. All right, I saw this. There's a recent case in South Africa now where some bodies have been found in a river. Some SAPS officers, some police officers, I think they're female. Their bodies, they were murdered, and somehow their bodies were found in a river. The investigation is still ongoing. I've been following the different investigators' comments, and so there's so much injustice and lack of trust in the judiciary, maybe lack of trust in the police, maybe allegedly. But this is actually me just trying to reflect on this event, that the whole court actually were clapping, when this Judge Rasmus actually spelled out this the judgment for these guys. It tells me of a South Africa that is hungry for justice, a South Africa that is hungry to see justice in the land, because a lot of people probably go through events without acquiring adequate justice for these crimes. And that was actually what I got from this. And somehow I'm also really, it's a bittersweet. Some commentators have described this whole Joslin Smith's case as a bittersweet judgment, because it might be sweet in the sense that the perpetrators, after this whole long time, have eventually been found guilty of kidnapping, all right, of this baby Joslin Smith. But the problem now is we still don't have Joslin Smith, all right. I really wish that, if possible, somehow the mother can actually just speak and say where the daughter is. I think her house was even set up in flames. I think I was listening to the Saldanha Bay was it the premier now? He was actually speaking about how the house of this mother of Joslin Smith was actually set up ablaze by, I think, the residents of Saldanha Bay after this judgment. And really unfortunate circumstances, but I think it was really, for me, really hitting, the clap in the court when the judge was reading out this judgment, and how excited people were. South Africans are really hungry for justice, and I still have faith and hope that the justice system in South Africa would keep on still striving for the justice, because a lot goes on in the land that really requires this kind of excellence by judges and the judicial system, despite the whole racial narratives that seem to constantly divide the nation. But let's quickly watch the moment where the Judge Rasmus spelled out the judgment for the perpetrators of this, what has now been termed kidnapping of the young baby Joslin Smith, and share your thoughts in the comments.
Now, before I make a pronouncement, I also have to deal with the indemnity of Ms. Lombard. I have decided not to deal with that application, or my determination of it now. It will be clear from what I've said so far that there will be another stage in this case. And one doesn't know what more evidence might be presented at that stage that might influence that decision. Furthermore, in the event that I have doubt on that question after all the evidence in the case has been laid, I might consider wanting to grant Ms. Lombard's legal representative to address me on the issue before final determination is made. But the primary reason is that I foresee a possibility that evidence might still be laid in the next phase of this case that might impact that decision. So for the reasons that I have stated, I'm of the view that the state succeeded in proving the guilt of Mr. Apollos, Mr. Van Ryn, Ms. Smith on the main count in count 1, and on count 2. So the following order is issued. You may remain seated. On count 1, you are guilty of a contravention of section 4.1 of the Act, read with the other legislation on trafficking in persons in relation to Joslin Smith. On count 2, you are also convicted of kidnapping in the direction of that. Can I just ask the public, please just bear with us. I know that's emotional, and I understand the expression of your emotions. Let us complete our process that we need to do for now. Then I'm going to adjourn. Then you can express your emotions as you wish. Are you 69s? Certainly. Mr. Policy must listen.
On the 27th of October 2020, there's a conviction of theft committed on the 22nd of August 2020. The sentence imposed was a fine of 10,000 rand, or 10 months imprisonment, which was wholly suspended for 3 years on condition not again convicted of theft or attempted theft. And there was also a declaration that he is unfit to possess a firearm. My Lord, that is the only conviction against accused number 1.
Mr. Paulus, do you admit the previous conviction? Good. You will be given the form to sign. And I'm not sure whether... Do you have a fingerprint pad here? You can do the fingerprint later, warrant officer. Just leave it there so long. Leave it back so long.
My Lord, if I may then proceed, Mr. Van Ryn. On the 3rd of October 2014, convicted of 2 counts of robbery, which was committed on the 17th of March 2014. The 2 counts were taken together for purposes of sentence, and 24 months imprisonment, which was wholly suspended for a period of 3 years, on condition that he's not again convicted of robbery or attempted robbery being committed within that period. And there was 12 months correctional supervision imposed, and he was also declared unfit to possess a firearm. The next conviction is on the 17th of January 2016, also for robbery, committed on the 23rd of October 2016, and there the sentence was 2 years imprisonment. And then the next previous conviction is on the 28th of March 2018. That was a contravention of Section 4B of Act 140 of 1992, possession or use of drugs, committed on the 26th of March 2018. The fine there was 100 Rand or 5 days imprisonment. My Lord, then the next one is on the 9th of December 2020, convicted of housebreaking with the intent to steal and theft, committed on the 4th of October 2020. He was sentenced to 24 months imprisonment. On the 11th of June 2021, released on parole supervision, which was supposed to be until the 8th of December 2022. There was, however, an extra endorsement where he was readmitted. The endorsement date was the 28th of October 2021 to serve the remaining portion of the sentence, 407 days imprisonment due to a violation of the parole supervision conditions. Those are the previous convictions of Mr. van Ryn.
Mr. van Ryn, do you admit your previous convictions? Thank you. All right. So whilst the administrative tasks are being performed by the constable, we now need to plan. So I'll tell you what my prima facie view is. We should maybe postpone the matter to a holding date, which will be a date, say, not this coming week, the week thereafter in Cape Town. I will deal with it early in the morning. And by that date, we will then determine whether you're going to lead evidence in aggravation. I suspect so. Whether the defense wants to call any witnesses in mitigation, then we'll know how many witnesses we need to call. I hope nobody's going to ask me for correctional supervision report because it's not applicable. No, I'm talking to the defense already. I'm talking about correctional supervision, but we also don't know whether there are any other assessments to be done. So once we know that, we will have an idea how long it will take to compile everything, but also how long we will need for the sentencing proceedings. And then I would want to come back here, because I think it's as fair that we do it here. But all the prep work we can do whilst we're in Cape Town, it will also give me the opportunity to, I thought I might still have to go to the office in town today. I was supposed to be in Cape Town today, in the office. But I'll see what I can arrange. So that's just my idea. How do you feel about that from the state side?
That sounds good, my lord. The state does intend to lead some evidence. At least victim impact statements will definitely be prepared. If the defense, if I may just ask, if the defense could perhaps indicate whether they want to apply for probation officers, then we can assist. Thank you, my lord.
Mr. Harmsen.
Obviously, defense on behalf of the accused one would need to consult with him. I am in agreement with the arrangement proposed by your lordship for a date in Cape Town. We obviously need to consult with the accused one and then take instructions as far as the procedure further.
Will you be able to, next week Friday, will you be able to advise me by next week Friday? In other words, I can postpone the matter till Friday next week, which is the 9th of May. I doubt that I have appeals, but we will have a courtroom available, so I can do it in one of the courtrooms there. That's just for everybody to report back. This is what we want to do, so that we can start planning from there.
Yes, it sounds in agreement. I'll be in agreement with that for the 9th, yes, my lord.
And then we can say we do it at 9 o'clock.
Yes, I am in agreement, my lord.
Ms. Nkabai?
Morning, my lord. I'm Kabai on behalf of Mr. Van Ryn. I would concur or concede with my learned colleague's submissions that the matter be heard on the 9th. I have to consult with my client, and I will, on that day, explain to court what are my instructions.
Mr. Sivnarine, similar? Okay. All right. So what I'm going to do is, it's 10 to 1. Right. I'm going to clearly they must be transported to Polsmoor. It's going to be difficult now if I issue the order now for Polsmoor. So I'm inclined to do 2 warrants, 2 detention warrants. To authorize both places. In other words, I say at this place and or that place, so that maybe tonight they can be held closer so that they don't have to take the R27 on a Friday in the middle of a long weekend. Otherwise, the police will only reach Polsmoor when tonight. And they're going to hit the peak hour traffic on their way to Tokai. So I'll hear from warrant if I say Malmesbury, and then during the course of the week they can make arrangements for them to be transferred. That okay? And will it be Langebaan for Ms. Smith for tonight? That'll just it'll just make it easier, because I can foresee problems if it's too late. Also, we're not sure what time they're going to leave from here now to wherever they need to go, because there's a lot of admin to be done. I'm also aware that because we made the arrangements the other day, that their parents might be here. I'm not going to make an order. It's not my place. But often what I do is, if I convict somebody, and if it is possible, I tell the court orderlies, if it's within your powers, I won't have a problem if you at least have their family speak to them before you take them away. Right? But I'm not going to make an order because I don't know what the arrangements are. So the following is going to happen. Mr. Van Rijn, Mr. Apollos, I'm going to do your warrant dual, so it will be Malmesbury, Polsmoor. Ms. Smith, I'm going to do you Langebaan, Polsmoor. You will be appearing at the High Court in Cape Town on Friday. All that will happen there is I will be informed how we're going to do the process further. And it will depend on availability of witnesses, reports, and so on. And once I have that and we determine a date, we'll postpone the matter back here for a day or two. It won't take longer than 3 days, I take it, to come and finalize the matter, where I will then have to impose sentence. I want you to give your legal representatives instructions as to what you want to do, because remember, there is a prescribed sentence of life imprisonment on count 1. Just remember that, so that you don't sit back and it's your choice, but so that I have everything before me, and I know the state is going to argue for life imprisonment. So just give your instructions. Members of the public, can you just remain calm now? I'm going to adjourn. Then give the police an opportunity to take Mr. Apollos Van Rijn and Ms. Smith out of the courtroom to their holding area. And then you can quietly leave, or if you then want to clap and ululate or whatever, that's your business. Right? I'm not going to stop you, but let's give them the opportunity to do their work. And then we leave orderly. Remember, we're a big number of people in this hall. Let's leave orderly, and thank you for coming. The court adjourned.